Good morning.
Good morning.
Now, you can take it from us that we have read quite widely, and also we'd like to know whether you've agreed a timetable, because this is listed for half a day, so we assume that you have that well in mind.
We do. We don't have a formal timetable in mind, but we are conscious of the fact that it's just a half day.
Thank you very much indeed, Mr. Wood.
Thank you. My lady, my lords, I appear for the Appellant Trade Networks Limited, whilst my learned friend, Miss Chantrell, appears for Extreme E Limited. Just by way of brief housekeeping, there is one small matter, which is that my learned friend has told me this morning that she's injured herself. I believe it's her writing hand.
Yes, I injured my right hand this morning. It's okay now, but if it flares up, I have a little bit of difficulty in using it, so I may have to take bundles a little bit slowly, if that's okay.
That'll be absolutely fine.
Thank you.
Yes, I also had in mind that if at any point it flared up, whilst I was giving my submissions, it would probably be fair to my learned friend to stop, to let her recover, and then
So that absolutely, so she's got a proper note.
Indeed. Thank you very much. You will have picked up, of course, that this is a second appeal, being from a decision of Mr. Justice Holgate, now Lord Justice Holgate, of the 12th of February, to uphold one of the grounds of appeal of the six raised by Extreme E Limited, and that led to the overturning of part of the decision of Ms. Stephanie Wilson on behalf of the Registrar of the 21st of August 2023. Now, my hope this morning, my intention, by way of a roadmap, was to touch very briefly on the nature of UK IPO proceedings, just to give some background. It may well be that you feel that's not necessary, and to then go through each of the steps of how we got here today.
We all appreciate, Mr. Wood, that you have the advantage of a tribunal which contains someone who knows more about this than virtually anybody, and then,
indeed,
for my part, someone who knows very little. So
indeed,
some limited background will be helpful just for me.
Indeed, as I believe you've read the transcript of the hearing before the High Court, you will have seen that my learned friend at the time, it was Ms. Blythe, did try to take Mr. Lord Justice Holgate through a little bit. I'll start again, and obviously if there's anything where you think I need to just move on, just please do let me know. I think that the first thing to say about the nature of UK IPO proceedings is that they are inherently low cost, and it's very, very common in drafting oppositions to have quite generalised pleadings that might say, for example, all of the goods and services are similar to all of the goods and services of the later application. That is, we would say, very common, and parties proceed on that basis very commonly. Equally, it's very common not to adduce any evidence on any particular allegations. And that, of course, has the consequence that the hearing officer is often asked or required to make their own conclusions from their own knowledge. And I guess the other part, which is very common, is for a hearing officer to make findings in their final decision on which they've perhaps not heard oral evidence, it's perhaps not been dealt with in the skeleton, and indeed you may often have decisions that are just on the papers where the hearing officer has not even had the opportunity to raise a point with the parties or their representatives. So this means that these IPO proceedings are inherently slightly rough and ready, I think might be one way of describing them. The other thing which I would mention, which is that there is a principle which comes through in the transcript of something called the Merrick principle, and I hope it may well be that you've already picked this up, but it's a simple point of construction, which is we call it Merrick identity, which is where, for example, the earlier mark relied upon is specific, and it's used to suggest to oppose a later term which is broader. If that smaller term fits within the broader term, it's deemed to be what's called Merrick identical. So for the point of view of identity, that's something to have in mind. So the example I had in mind was, for example, if the earlier mark was bathing costumes and you were opposing a registration of clothing, that would be deemed to be identical, even though, of course, there are many types of clothing that are either not identical to bathing costumes in the normal sense of the word, or equally could be potentially argued not to be similar to bathing costumes. It is a point of construction. Now, a party would typically seek to get around that Merrick identity by amending their specification. And of course, the Extreme E accepted the Merrick at the Merrick identity at UK IPO, and if you need a reference for that, it's page 126 of Supplemental Bundle, tab 7. So, if that's okay, that's that point dealt with. I'd like to just move on now and just talk about the two cases that are in the authorities bundle and are agreed. I should point out there are two in there where it's not agreed that they could be, they're not agreed between the parties. And those are the two earlier decisions of the EU IPO. And if I refer to them, it will just be in passing. But the two cases refer to the two steps that are very important in a trademark opposition. The first one is to understand what the terms of the specification, of the earlier mark, and of the later opposition are. And then once that's understood, you then go to look at whether or not those respective goods and services are similar. So the two cases that we have and that are agreed, the first one is the Avnet case, which is at tab 2 of the authorities. I'll just let you turn that up, if that's okay. And the line passage is at page 30 of that tab. And it is a principle accepted between the parties that in reviewing or in conceiving what the meaning of a term is within a specification, it needs to be done carefully, and you shouldn't give a wide construction. That's the first, second, third, fourth, the paragraph that begins, in my view. Now, that particular case was a case about double identity, and the question in that case was whether or not the infringer, who was providing email addresses and websites through which customers could publicise their products and ideas, that's what I take from the head note, whether that would be deemed to be identical to the term in the earlier the specification of the right alleged to be infringed, which said advertising and promotional services. And so Avnet says obviously you just need to look at that in a narrow sense and not take more from that.
And the rationale for that is that if it's double identity, likelihood of confusion is presumed.
Indeed.
And not only presumed, it's very difficult to rebut that presumption.
Indeed.
And so therefore that's why when you're considering identity, you need to have quite a strict test.
Indeed.
But if it's a question of similarity, it's quite different.
Well, it's a two-step approach. The first thing is to understand what the specification is, and then you come to look at whether or not the goods and services are similar. Now, there's a sort of a bridge between the two in that in the British Sugar case, the same point is looked at again, and that's tab 1 of the authorities. So the bridging point, I would say, is at page 9 behind tab 1. And this was a question as to, well, the first part, because there was a 10.1 and a 10.2. So identity of the goods in question and similarity. The first part was whether or not jam would be considered as a dessert sauce, and you can see in the line passage the court would say quite sensibly concludes that jam is not a dessert sauce.
Yeah, but again, he had to do that because one of the allegations was double identity infringement. So he had to decide, was there identity of goods or not?
Indeed, and so it's construed narrowly. But then, of course, we then move on at page 16 to look at the what we would call in the treat factors. Those are set out at page 16, starting on line 31. And I don't believe there's anything between the parties about the application of those factors. They are used in principally every single decision. And I think in my skeleton I put the simple gloss on there that although typically the treat factors are the only things considered, there's a small line at the beginning just before the enumeration.
Yeah, well, we know this is not the entirety of the law. For example, because one of the things that's not mentioned here is complementarity.
Indeed.
And as the hearing officer correctly pointed out in her decision, the Court of Justice has told us that complementarity on its own can suffice.
Indeed. Indeed. You don't have to have all of the treat factors in order for there to be similarity. It can be enough just to have one or two, like complementarity, as your lordship commented. So yes, so that's. Let me just move on. Sorry, that moves on. Yes, so those. It's a whistle stop through those cases. That's all that needs to be said on there. Needed to take you to them. So when we then look at where we get to, you can see that there were three sets of terms which are the subject matter of this appeal. Just three terms. It's common between us that the comparison in question in relation to two of those was not made either in the written case or in the oral case at the UK IPO, but equally, certainly at the High Court, nothing was made of that. There was no suggestion that there was any procedural unfairness about the fact that the hearing officer found on the basis of extending part of the reasoning to things where that point had not been put to the parties. I think that just has to be, and if you need, I don't know if you need to pick that up, but that's at tab 7, external page 105 at line 4.
Sorry, tab 7, page 105.
Sorry, of the supplemental one, I should say. Sorry. So that's the tab 7, external pagination 105. Yes, sorry, I should say that's where we deal with one of the comparisons. And then, sorry. Yes, so yes, I should say, we only dealt with one of the points, which was the point about booking seats for shows and the overlap with cultural activities. And we'll come back to look at that. So if I now look at the UK IPO decision, that's core bundle tab 9. If we pick that up at paragraph 97, sorry, page 97, I should say, paragraph 12 and 13. So you can see where the hearing officer begins to look at the relevant comparisons to be made insofar as the services are concerned, and you'll see paragraph 13, there's the reference to the treat criteria. And then if we move on to external pagination 100, this is where the hearing officer makes her decision. You can see there that she says, in fact, let me leave you to read that paragraph.
107.
Yes, so, sorry, page 100, paragraph 21. It's the first of the paragraphs that's been the subject of the appeal before the High Court. And Shall I proceed? Lovely. You can see there that obviously there is the recorded as my submission that the term could include the provision of theatre shows, and that's the part of the transcript that I just took you to. And the hearing officer says she agrees that there's some similarity between provision of theatre shows and booking of seats for shows. And you can see there that she says that the same businesses, there's an overlap in user, there's complementarity, and she looks at nature, purpose, and method of use. And those are each of these are the treat criteria. So she's looked at the treat criteria, she's assessed them, and come to the conclusion at the end of that paragraph that she considers them to be similar.
Do we have to worry about what she says about similar to a medium degree?
No. There are, it's not addressed in our skeleton, but you just need similarity to get over that hurdle. There are indeed many appeals before the appointed person, less so to the High Court, where appellants try to argue that actually the hearing officer gave it the wrong degree. And there's a reference in my skeleton to the grey box decision, where the appointed person, Mr. Purvis, suggested that that was not a good approach, because questions of degree are effectively neither here nor there. Certainly, when it comes to similarity, it's a binary. If there's similarity at all, we say that's enough.
It's not a binary question.
Okay.
It's, is there similarity, or is there, if there is, the degree of similarity is a spectrum. So, in other words, it's a question of whether there is similarity at all.
Mm-hmm.
As soon as you've got some degree of similarity, then after that it's a question of degree. And the point being made in grey box, and it's been made in many other cases, is that it's very hard to find any error of principle and an expression of opinion as to the degree of similarity.
Indeed. I'm grateful. Yes.
Anyway, your point is we don't have to worry about that.
Well, the point being made was that they're not similar at all, and that was the finding of Lord Justice Holgate. It was the finding of dissimilarity,
yes.
And thus the opposition for those services fell away.
Yes.
And we say obviously that is the judge replacing the view of the hearing officer with his own personal view. And we say that is wrong. Now, supplementary tab 3 contains the grounds of appeal. Let me just... So these are the grounds from by Extreme E Limited to Lord Justice Holgate. And yes, so at 34, you'll see that the ground starts. This is where ground 1 is reproduced, and that, as I say, was the sole ground that was successful before the High Court. And the operative paragraphs are paragraphs 5 and 6.
Sorry, which page are you on in the bundle?
Sorry, it's on external pagination 34.
In the supplementary?
In the supplementary bundle, yes, indeed. And you should have at the first page, page 21, the appellant's notice, and then...
Sorry, my mistake. Carry on.
No, okay. So you'll see that paragraph 5 says that the hearing officer wrongly interpreted the term booking of seats for shows. And this was effectively the rump of the dispute between the parties, effectively, whether or not the term booking of seats for shows was understood to mean the booking of seats for third-party shows, and that's where the AVNet point comes in, or whether or not the intention was...
Not really. The AVNet point came in with regard to the applicant's specification, because you don't dispute that in your specification, booking of seats for shows is a standalone service. That's to say, it will be third parties. You're very clear about that. I think it's paragraph 12 of your skeleton. The issue is when you turn to the applicant's specification and what that, first of all, what it embraces. Secondly, where you then stand with regard to similarity. And that's where there seems to have been the dispute before the judge. And the judge says, well, in that context, the hearing officer must have meant that when it's the organiser of the show, they're booking seats for their own shows, to which you say, fine, but so what?
That would be correct, but I have to, and that's not how I, perhaps I'm wrong, but my understanding was not that, but in fact that the interpretation was actually of the applicant as meaning booking of seats for shows, that it had been extended to mean the booking of seats for your own shows. And perhaps I'm sure my friend will correct me on that when she gives her submissions. But in any event, paragraph 6, the appeal says the hearing officer was wrong to conclude that the same business that provides and organises shows will also provide that third part, the service of booking of third-party shows, and as a result says shouldn't have found there was an overlap in the user of those services. Now, so I'm not sure that's a correct proposition anyway, but that's the way that it was. That's the way that it was put. So that's the rest of the. And if the hearing officer was wrong on that, then that flows through into the rest of her decisions in the other paragraphs. Now, if I can ask you, are you happy for me to move forward to the transcript of the hearing before?
Well, why do we need to look at the transcript?
Okay.
I mean, by all means, take us there if you think there's something we need to see. But what matters is the reasons that are given.
Yes.
And the focus is on the question, as I think I've already referred to, was the judge entitled to interfere with the hearing officer's decision, given that the hearing officer's decision is a multifactorial evaluation?
Yes.
Your basic point is you say the judge was not entitled to interfere.
You are well ahead of me. I was perhaps in a more pedestrian way taking it through to show how unreasonable it was and how we were right. But you're so far ahead that I'll just jump forward. Yes, the simple point is this, that the hearing officer, we say, was entitled to reach the conclusions that she did on the basis of what was there. There was no evidence, and as the parties have agreed, there's no requirement that there be evidence and no suggestion that it's unfair for a hearing officer to come to a conclusion in the absence of evidence. Now, it might be said that in this particular case, all of the goods and services in question are things that they're not specialist, we would say. And so the hearing officer could, in any event, as the avatar for the average consumer, reach those conclusions. Now, we say what's happened in the decision of Lord Justice Holgate is that he has displaced that appreciation and obviously substituted his own. The decision suggests that that effectively Ms. Blythe for Extreme E made various submissions about the nature of the market, which is correct, and that we had nothing to say on the matter. In fact, what we tried to do was bring things back to the question not of whether the judge had a particular perception of things in his own view, but actually the question as a review is whether the hearing officer was entitled to a view, and they are two separate questions. The question is whether the hearing officer was entitled to come to that conclusion, not whether the judge on appeal might have come to a different conclusion.
Review, not rehearing.
And it's that simple point. Exactly. I mean, it goes back to the same point. Now, of course, against me, I'm sure my friend will say, well, where there's no evidence, it's open to a judge to reach his own conclusions on whether or not a hearing officer was correct. But I think given...
Yes, but then we get into all the authorities about specialist tribunals and the respect to which they're entitled.
Indeed. And I feel that...
To what extent...
Yes.
Did the judge's decision turn on his interpretation of what the hearing officer decided, as opposed to his own interpretation of the issue?
My reading of the decision was that he didn't necessarily...
It's the third. I'm thinking of the third party point. The third party
Yes.
tickets point.
Oh, absolutely.
And I've read the exchange about that from the transcript.
Yes.
The exchange with you.
Yes. So, could you ask a question again? I'm sorry.
Well, to what extent?
Yes.
So you're saying the judge wasn't entitled to reinterpret the. I'm paraphrasing.
Yes.
I'm sure imprecisely. But your case is the judge wasn't entitled to substitute his own assessment for that of the hearing officer.
Yes.
But to what extent was he in fact basing a decision on his interpretation of what the hearing officer decided, as opposed to his own interpretation of the issue?
Well, I think if we look at the decision, there's not really, you don't see consideration of paragraph 21 in the way that one might have expected. In fact, if we go to the decision, let's look at exactly what he says. I think that's probably the helpful.
Yeah.
Let me. So that is behind tab 7 of the core bundle.
Yes?
And behind, so I think the relevant part starts at page 76, external pagination, and paragraph 15. And when what you'll notice is that what he doesn't do is effectively look in a clinical way at the findings in paragraph 21 and say the hearing officer was not entitled to those conclusions. The real thing which we say that the judge focused on was the interpretation point, and you'll see in our skeleton that we say that he made the mistake of confounding the core and ancillary point and didn't actually look at whether or not the hearing officer had...
I may be barking up the wrong tree, but I was focusing on what was said by the judge in paragraphs 28 and 29 of the judgment. That's what I was wondering.
Yes.
Where
sorry.
he... it seemed to me that he was basing his decision on his interpretation of what the hearing officer had decided.
Well, I think I wouldn't necessarily say... I mean, when you read paragraph 28, what you see is that Ms. Blythe had given her own submissions, and that was then what he relied upon. It may well... I mean, I'm trying to see if that makes a difference. I mean, I think our position has to be that it wasn't necessarily on what was in the earlier decision, but on the basis of what Ms. Blythe had submitted at the appeal hearing. Now, obviously, when we move on to
So what you're saying about paragraphs 28 and 29 is
he's looking at paragraph 21, but he's looking at through the lens of the submissions that have been made specifically to him, and
Yes.
he's intertwining the two.
Yes, I'm over.
And so therefore coming to his own conclusion based on the submissions made to him.
As to what exactly, I think exactly the submissions from Ms. Blythe may have accorded with his own personal views on how he might have decided it, but we would say that that's not the correct approach, because all of the authorities say it's not enough that you might have come to that you might have decided it differently. And
Yeah, all right, but we need to try and focus upon what the correct test is and how it applies in the circumstances of this case. So, there was never any dispute before the judge that the hearing officer had correctly stated the law as to the comparison of goods and services.
Yes.
It's textbook stuff. No, not the faintest suggestion of any legal error.
indeed,
So, the question is, what error of principle is the hearing officer said to have made? And you've helpfully drawn our attention to paragraphs 5 and 6 of the grounds of appeal, which set out, and sporting services is a different question, we'll come to that later. But so far as the non-sporting services are concerned, the error of principle that's alleged is one of interpretation of the specification of services.
yes,
Now, we then have to ask ourselves, well, how is it said that the hearing officer has gone wrong? On the one hand, she is comparing the service booking of tickets for shows in the opponent's specification, your specification,
yes,
and on the other hand, she has this list of various services in the applicant's specification.
Yes.
Now, we need to separate those out, because so far as booking of tickets for shows is concerned, you're very clear on that, as I observed earlier. It's paragraph 12 of your skeleton argument at page 37 of the core bundle. And you say, it's in the context of things that are so obvious they don't need to be discussed. And you say the question whether the service of booking tickets for shows means a third-party service rather than a purely internal service, which is an unjust offering such as one such issue. The UK IPO's hearing officers are aware the classes contain services, which mean the provision of those services is a separate offering. So, very clear. In your specification, it's a separate offering.
yes,
So we're talking, therefore, about third parties.
yes,
That's a very proper concession and is clearly the correct starting point. But then we turn and look at the applicant specification.
yes,
And the focus of the alleged error is the third sentence in paragraph 21.
yes,
There's no dispute taken about the fact that the applicant's specification includes theatre shows, among other things.
Yes.
And theatre shows are a convenient example because we're all familiar with them. And she says there's similarity
yes,
with your booking of seats for shows, and she gives a number of reasons. And the first sentence in her reasons says the same businesses that provide and organise shows are also likely to provide services for the booking of seats. Now, for reasons that slightly mystify me, there seems to have been an issue before the judge as to whether she is there referring to booking for third parties or booking for their own. And the judge's conclusion is, well, she must have meant booking for their own. And that seems to me to be correct when you look on paragraph 22, because there she is explicit. She says in paragraph 22, I accept that the organisation of different types of events would also involve the provision of a booking service for seats at that event. So she's explicit there that she's talking about own shows, not third-party shows. And there's no reason to think she meant anything different in paragraph 21. But the question is, why does it matter? And as I understand it, your argument is very simple. Yes, the hearing officer meant what the judge said she meant, but doesn't show she fell into error. Because you still have to go on and consider similarity. And that's what she does.
Yes.
She says there's an overlap in user. You say, well, that's plainly correct. Then she says they're complementary, to which you can say, well, there was no challenge to that in the grounds of appeal. Whether it's right or not, one can debate, but it wasn't challenged. She says nature and purpose method differ. Well, again, one might question that on the basis it's a bit inconsistent with paragraph 22, but again, there was no ground of appeal on that. And then she says, well, similar to a medium degree, that's an evaluative decision. You say, no error of principle. Simple as that.
Yep. I'm not. I'm grateful. I'm not sure how to follow.
But what about the sporting? That's right. That's where things get a bit more tricky.
In that paragraph, in that same paragraph 22.
No, it's paragraph 22.
22. Okay. Yes. Well, moving on. Okay. Well, that's. I guess we have. I guess we have two parts there. The first part is. Well, I mean, if you read paragraph 22, clearly it says that there is different kinds of events, but they themselves have a booking service. And she's considering there, I think, if one reads it properly, booking of seats for the sporting events versus booking of seats for shows, and concludes that there be some overlap in nature, user, method, and purpose. And frankly, I think that is something that she was entitled to as well. Again, she does all of the treat factors again and reaches an evaluative decision. So that's a solid finding as well, we would say.
Yeah, and so she's particularly looking at things. I mean, she doesn't. She just refers to different types of events, but in the context where her heading
it must be
starts with organisation of motor vehicle races, entertainment in the form of live motorsport races. Yeah. It's motor races that she must particularly have in mind.
Indeed, and of course, has been earlier in the yes, indeed. I don't need to labour that particular point. I'd agree.
Well, where does that take us to? Because one the alleged error there is.
This is the error at the High Court. Sorry, just to check.
Yeah.
Yeah.
The proposition that a show is confined to theatrical show is rejected in paragraph 35.
Again, it's a false premise. This question as to whether or not shows includes sporting events or not doesn't really matter in the context of that paragraph.
Yeah, so the focus of the criticism seems to be in 36 and 37. And the point made in 36 is why is a motorsport event considered as a show? To which you say, well, that doesn't matter. The test is not identity, it's similarity.
Indeed.
And then there's a point that sporting events don't necessarily involve the use of seats, which you say that's rather strange.
Yeah.
Particularly if you think about a motor race, most of the spectators are seated.
And it doesn't matter if some are. As long as some are, the fact that some aren't doesn't mean that it's dissimilar for everything.
Yeah.
And that's effectively the Merrick point again of sorts. So that deals with that point, I think.
Could I?
Yes.
If I just take you back.
Yes. Yes.
And just focus on the point before. again, just if I may, for just a moment. Is it paragraphs 32 and 30? I took you to 28 and 29 of the judgment. Is it in fact 32 and 33 where you say the judge went wrong?
Well,
of the judgment on page 79.
let me just turn that up.
So tab in the judgment, tab 7.
Yes, indeed.
Mr. Justice Holgate's judgment.
Indeed. I mean, the parts at 36 and 37.
Yeah, paragraphs 32 and 33.
Sorry, 32 and 33.
Yes, Lord Justice Baker is going back to the non-sporting services.
Yes, I'm so sorry.
Because
the sporting point is, as it were, an additional issue. He's before he gets to sport. He's decided the case.
Indeed.
On ground 1, on 30, 32, 33, 34.
Yes, and that you're correct. That's where the rump of it is for the non-sporting.
And could I again trouble you? What specific point? I think it's going to be in 33. As you say, he was wrong. He was wrong.
Well, in 33, it's effectively that second paragraph where we say seeks to move book for shows organised by third parties doesn't include the organisation of shows, and then moves on to look at core, completely ignoring the treat factors that are dealt with properly.
Yeah. So he's looking, as he says, for overlap.
Yes.
And you say the absence of overlap tells you that there's no identity, but it's not conclusive of the question of similarity.
Indeed, and this core and ancillary point is really an identity point, and really the key bit to look at was treat, and that was dealt with properly. And whilst he says that he is referring to treat, he doesn't then go on and do
paragraph 33, he failed to apply the treat factor.
Indeed. Yep.
Thank you.
So I think actually that, whilst it isn't necessarily the way in which I envisaged going through all the different grounds, I think that deals with, in reality, that it's been portrayed in a slightly different manner, but I think it shows the errors in the judge's reasoning. Let me just, if I look back to the grounds of appeal that we've made. So yes, starting, I'm just going through page 14 of the core bundle to look at the grounds as we presented them. I have to say, given the assistance of Justice Arnold,
yes.
I'm not sure I have.
Even with the interference of Lord Justice Baker, you've managed.
No, I think it's been, let me put it this way, slightly dealt with, not necessarily in the way that I had anticipated dealing with it, but I think all of the points are dealt with unless you have any further questions.
Well, what remains is the respondent's notice. Now,
sorry.
when you are opening an appeal, there's two ways of dealing with the respondent's notice. You either can anticipate the submissions or you can deal with it in a reply.
I intended to deal in a reply, I should say.
All right?
Thank you.
Thank you.
Unless you have any questions.
No, thank you. Ms. Chantrell, are you ready, or would you like a
Yes,
break
I'm
before you
ready.
begin?
Thank you.
Okay.
My lady, my lords, the way in which I propose to deal with my response is just by reference to what was discussed this morning. There were a number of grounds, A to G, that were raised, but I think we've only really talked about D, E, and F this morning. In relation to the other three, you have my submissions in my skeleton argument, so I didn't propose to repeat them. And then I will, of course, deal with the cross-appeal. Before I get into ground D, which is the first one, there were just a a couple of points I wanted to respond to in respect of my learned friend's opening. The first was he said that proceedings in the UK IPO, generally evidence on particular allegations is not necessary. That's absolutely right. That's one qualification. There are, of course, issues where evidence will be necessary. For example, if a party has to prove evidence of use or goodwill or other issues, that isn't relevant here. I think what my learned friend was saying was in the context of similarity in goods and services. That is usually an area where evidence isn't necessary and the hearing officers can...
well, more generally, on Section 5.2b
Yes,
cases,
that's correct.
subject, as you say, to the qualification that the opponent may be needing to prove use if it's more than 5 years old.
Exactly. And there may be situations where particular goods and services are unusual, and the opponent may wish to explain why the market is a certain way and why there would be or would not be would be similarity in the case of an opponent. The second point was on the case law. Now, there is no dispute between the parties on the legal issues. There was one point that my learned friend raised, which I just wanted to reiterate, and that is that this is the assessment is a two-stage process. First, the hearing officer or the court needs to construe the specification and work out what is the core meaning of the specification, and then, for the purposes of a similarity, go on to determine whether there is similarity
Well,
between...
for the purposes of comparison, would you dispute that interpretation of specification is mainly relevant to the question of whether there's identity of goods or services, not to the question of similarity?
It is mainly relevant to identity, but it is also relevant to similarity, because before one goes to compare the services, one needs to decide what is the core meaning of those services, and then work out, by reference to the treat factors, whether there is similarity.
Well, one thing that's noticeable by its absence in the hearing officer's decision is any discussion of interpretation of the specification or the relevant principles. And that's not an accident. You can look at hundreds of hearing officer decisions on 5.2b and you will never see any reference to that.
Yes. Yes, but of course I completely accept that. But there is a job that needs to be done to work out what the goods and services mean before comparing them. It may not matter as much because the test is different, but it is still relevant as to what the meaning of, for example, the booking of seats for shows means. And once the hearing officer or the judge has construed that, they can then work out whether, when applying the treat factors, there is similarity. Without construing it, the exercise cannot really be done. So I accept it is more important in the context of a double identity case, but it is still relevant to the assessment of similarity. Now, in relation to ground D specifically, you will have seen from my skeleton argument, and still my understanding, that there are essentially three complaints that are being made. The first is that the judge undertook a rehearing instead of a review, so applied the wrong test on appeal. The second is that essentially what the judge did was carry out an assessment of double identity and didn't have in mind...
Well, it's not double identity, it's identity.
Identity, sorry,
Because
identity.
it's not,
yes.
never suggested that the marks were identical.
No, sorry, yes, I apologize. Identity of the services and not one of similarity. And then the third, which is related to the second, is that the treat factors were not taken into account and applied. Now, in relation to the first, it's accepted by my learned friend that the judge did have the right principles in mind, but what he says is that they were not applied. Now, there's just one short point I would like to make about that, and that is if I could ask my lady and my lords to take the judgment, core bundle tab 7. Now, the first paragraph I would like you to look at is paragraph 41.
41.
41, yes, on page 80. Now, this is just by way of reminder that there were a number of grounds that were raised on appeal. And in respect of grounds 2 onwards, the judge did reject them, and he explains the reasons for rejecting them. And they were very much in line with the relevant principles. Now, paragraph 41 is an example of that, where he says that, and this was in the context of the visual comparison of the marks. He said that, I find it impossible to say that the officer's conclusions lay behind the range of judgments to which a decision maker could properly come. Same at paragraph 43. I won't take you through all of them, but what it shows is that he very much had in mind what the right test was on appeal and where he found it.
But doesn't that make Mr. Wood's point for him? Because there, as you accept, he's asking himself the right question. But where in paragraph 33, for example, do we find him asking himself whether the hearing officer's conclusions lay beyond the range of judgments to which a decision maker could properly come?
I will come on to where I say he says that. It is brief, I accept that, but I do, the point I wanted to make here was just that he had the principles in mind. He clearly applied them in the context of the other grounds, and we say he addressed ground 1 no differently, with no different test in mind. I will come on to where he says, that the test was not satisfied in the context of ground 1 in a moment. The second point I wanted to make, and this relates to the second and third complaint. So this is the treat factors and the identity test that was applied, allegedly applied. Now, the starting point there is that it was common ground between the parties, and this is reflected in paragraph 12 of the judgment on page 76. If I could just ask my lady and my lords to read paragraph 12. So it was common ground there that if the court upholds ground 1, and there is a question as to what that means, upholds ground 1, but if the court upholds ground 1, there was no dispute between the parties as to the effect of that. And what he says there is that the finding of similarity would be replaced by finding of dissimilarity. My reading of
But that was ground 1. Ground 1 was that the hearing officer ought to have found dissimilarity, and the point that's being made there is not perhaps terribly precisely expressed, but the point that he's reflecting there was that it was common ground, rightly, that if there was dissimilarity, there could be no likelihood of confusion.
In my submission, that isn't quite what he's saying there. What he's saying is if the court upholds ground 1, and I will come on to explain what the meaning of ground 1, upholds ground 1 means, but he says the officer's finding of similarity would be replaced by finding of dissimilarity. What, in my submission, that means is that there was no dispute as to how the treat factors would be applied, and that the logical conclusion of finding in my client, in the respondent's favor on ground 1, was that the services were dissimilar. And then naturally then, as a result of the services being dissimilar, he didn't have to go on to determine whether there was a likelihood of confusion. That is my understanding of what that paragraph is saying. And the reason I make that point is because of the way the case was actually presented to him. And I will take you through how the case was presented to him, because it makes that paragraph and a few of the other more brief paragraphs a little bit more clear in my submission. Now, this leads me on to what is the meaning of the court upholds ground 1. Now, in essence, my understanding of ground 1 is that what the respondent was saying was that the hearing officer had failed to apply the principles in AVNet. And that is that she failed to apply, or she failed to have in mind what the core meaning of the services was for each of the services before she then went on to carry out that assessment.
Yes, but I'm sorry to interrupt you.
No.
But there's no doubt about what was being meant. If you look at Ms. Bly's skeleton argument
Yes.
before the judge, so this is Supplementary Bundle, tab 1,
Yes.
page 7. And it's paragraph 23.
Yes.
In summary, therefore, the appellant submits that the hearing officer ought to have found that there was no similarity between the respondent's service of booking seats for shows and the Ground 1 services, or in the alternative, just the sport-based event services listed in paragraph 22. As such, there was no need to consider the likelihood of confusion in respect to such services as the threshold requirement of similarity of services not been met. And the footnote tells you that paragraph 10 wasn't pursued. Paragraph 10, when you look at the grounds of appeal, was the alternative argument that what the hearing officer ought to have done would have said that there was only a low degree of similarity.
Yes.
So the low degree of similarity point was not pursued. So that what was in front of the judge, as we see from this paragraph, was a very straightforward proposition, namely no similarity, therefore there can be no likelihood of confusion. And that must be what the judge meant, surely.
Yes. Well, slightly a little bit more complex than that. What was submitted, and I will take this very briefly in summary, but then I will take my lady and my lords to the documents. What was submitted was that the hearing officer had failed to interpret the services or construe the services in a way that was by reference to their core meaning. Once one does that, then the knock-on effect of that proper construction is that there is no similarity as a result of that. Now, she explains that in the skeleton argument, which I will take you to. But the second part of that, which is the knock-on effect once they're construed, there was no dispute about that. There were no submissions that were made on the treat factors. There were no countering arguments made in respect of how the construction then goes on to, the proper construction goes on to affect the conclusion of similarity by reference to treat. And that is why I say that once the judge had found there was an error in terms of how the services were construed, the conclusion or the knock-on effect of the services being dissimilar was not in dispute between the parties. And that is what I say he is reflecting there in his paragraph 12. Now, ultimately, in my submission, that doesn't matter, because in my submission, I'll be saying he did actually have in mind the treat factors, and he did consider whether there would be a likelihood of confusion, despite there being no submissions advanced by my learned friend, and that he did that with the right principles in mind, and then found that there was no confusion. So that is why I interpret paragraph 12 in that way. And if I could, my lord took us to the right bundle. I did want to take you to paragraph 13 of the skeleton argument, because that is where the respondent's case starts in respect of ground 1. The previous paragraph, she just explains the different services. Paragraph 13 is the starting point of the criticism. This is on page 4 of the supplementary bundle. Now, so she says, when interpreting services, it's critical to keep in mind the guidance of Jacob J, as he then was in Avnet. She then says that the appellant submits that the hearing officer failed to apply this guidance and therefore gave the services in question a construction that was far wider than their core meanings. And then she goes on to explain at 15 onwards what the core meaning is of those services. So in short, what she says is that the selling of tickets, when the event organizer is putting on an event and is selling tickets, they're not selling tickets as a service, as part of their core service. That is what she calls an ancillary, an incidental part of the service. But the core service that's being provided is the provision of the event, and providing the selling of tickets is not an additional service by reference to its core meaning. It's not a core service that's provided. That's me summarizing what she said in paragraph 15. and 16, sorry. She goes on to explain that the booking of seats, and this is not in dispute, is a distinct service where the event event organizer is offering. It's not offering the booking of seats as that core service. Then 17, she says, by contrast, the booking of seats for shows, that is a specific service that is being provided in respect of third parties, and that was the exchange this morning, and that is not in dispute. But then the core part of this skeleton is at paragraph 18, where she says, in the premises, it is submitted that each of the ground one services, when confined to its core meaning, does not include the service of booking seats. Now, what that means is, as I explained before, the service of booking seats as opposed to an additional selling tickets for one shows. Now, the reason this is here is because it directly relates to paragraph 21 of the decision, which is in the core bundle tab 9. And if I could just ask you to keep the supplemental bundle open here, because I will come back to it in a moment. So this is tab 9, page 100. We've looked at this already this morning. Paragraph 21. The sentence that she says was where the error is the same businesses that provide and organize shows are also likely to provide services for the booking of seats. So what she's saying is the error here is to find that there is a service of booking of seats that's being provided by the event organizer.
And what's wrong with that? If I want to book a theatrical show, I have, generally speaking, two choices available. I can contact the organizer directly by telephone or book it online. And in most cases, they will provide me with that service and they will charge me a booking fee for it.
Yes, perhaps.
Or I can go to an agency to get that service and again be charged a booking fee. So what's wrong with what the hearing officer says there?
Well, my understanding of what was said to be wrong was that the core service that's being provided by the event organizer, and I'm saying event organizer, there are a number of different services that we're talking about here, the sports and cultural, but the event organizer is providing the event. They may also sell tickets as part of that event, but the average consumer won't be thinking that that is their core service. It is the event that is their core service. This is an ancillary part of what they do.
Well, this would all be very important if one was concerned to establish whether the services were identical.
Yes.
But on an analysis of similarity, why does it matter?
It may not matter when one comes onto the treat factors, because when one looks at the treat factors, one may say, well, it's not a core service, but it may be complementary. For example, that may be one of the which
that's
is, I know
exactly what the hearing officer does say.
I knew that was coming. Yes, paragraph 21. Yes, it may be, but the point that was being made here was that it's the first step, which is the construction, was that the hearing officer was saying that the provider, the cultural service and provider, the organizer of sporting events, is providing that service. And what she was saying was that is because she had made this this finding, she did not have AVNet in mind, because it is not a core service, a core part of the service to provide a service for booking of seats. And that is why she said there was an error, was because had she had AVNet in mind, then she would not have found that the services of booking of seats was a core part of that. Now,
could you just, for my benefit,
sorry, yes.
say where precisely you say in paragraph 21 that the hearing officer went wrong on the judge's interpretation?
In that sentence, the same businesses that provide and organize shows are likely to provide services for the booking of seats. Now,
But on the judge's interpretation, as I put to you earlier, that is simply a correct statement. She's talking about booking of seats for their own shows, And as the theatre example shows, it's correct.
Yes, and it depends on how one interprets that sentence. It may be that all she is saying is they're providing ancillary services for the booking of shows. Sorry, for the booking of seats. What was submitted, we say, and what was accepted by the judge was that this actually means providing a core service of booking seats. And that is why, in paragraph 18 of the skeleton argument, it was said that when one looks at the services by reference to their core meaning, it does not include such a service being core in that way. Now, what she then, and I'll just take you forward to what she then says.
Can I just put to you this question? And I take your point that there's a question of whether this is core or incidental, which was raised.
Yes.
But one reading of this is, first of all, the third sentence be interpreted in the way that I've just suggested, namely the way the judge read it, and Mr. Wood doesn't push back against that very strongly. He says it doesn't make any difference. But reading on, one asks oneself, well, why does she say that? And it might be suggested that the reason why she says what she says in the third sentence is because it provides the foundation for what she says in the next two sentences. There's an overlap in user. And take my example of the theatre booking. Mm-hmm. She's plainly right about that. It's a 100% overlap.
We don't dispute that.
Right. So, and it's also a foundation for the statement of complementarity. In which case, where's she gone wrong?
Well, it may well be, but the position that was taken was that in fact, what the hearing officer decided and what the hearing officer had in mind was that the entity that is providing these cultural activities is providing that as a core service. And that is how the decision was interpreted, and that is why the respondent said that there was an error, because she did not have AVNet in mind. If she had thought that it was a potential ancillary service, she could have said, well, she may have expressed that, but that is how the, sorry. Yes.
I'm sorry to bombard you with questions, but just so as we're clear about the third sentence, because I appreciate the point that you're putting forward, supporting the argument below and the decision below, is that it's important to distinguish between the core and the service and the ancillary service. Now, let's assume that that's right for the moment. What do you say is the impact of the word also? Because she says the same businesses that provide and organise shows are also likely to provide services for the booking of seats. Now, it might be said against you that that is recognising the very distinction that you're arguing for. Namely, she's not saying that providing and organising shows includes the service of booking of seats. On the contrary, what she's saying is the person who does the one service will also do the other service.
In my submission, the use of the word also supports my interpretation, because what she's saying, what she's identifying there, are the two core services that are being provided by that entity. So she says the business that provides and organizes shows also provides a service of booking of seats. It has the same impact, it's the same importance, and both of them being core to what that entity is providing.
So your submission is she's treating both as being core services?
Yes, that is
All
my
right.
submission. Now, if I may move on to the next part of this skeleton. Now, paragraph 19, this is on page 5, I think, of the supplementary bundle, which I still have open. Paragraph 19 and 20, what she does is she explains a different case, Citibank case, and I won't take you to that. The next paragraph, which is relevant here, is paragraph 21. Now, this is where the respondent's counsel applied the treat principles. So she says, booking of seats for shows is not the same in nature, intended purpose, for each of ground one. Now, that was already what the hearing officer decided. She doesn't reference the overlap in user because there isn't an objection being made to that. But she does address complementarity. And she says they are not complementary in the sense they are not indispensable or important. And then she says, she provides a reference to Boston Scientific, and then she says the hearing officer ought to have concluded that there's no similarity between the services. Now, that the consequence of this is that the only factor that remains from the hearing officer's decision is that overlap in user. What she's saying is that it's complementarity that shifts as a result of that.
I can understand your reliance upon paragraph 21, but what do you say to this? First of all, it was not a ground of appeal to the High Court that the error that the hearing officer made was in making a finding of complementarity. Secondly, that wasn't the judge's reason for overturning the decision.
Yeah, well, the point that she made was once one construes the services properly, the knock-on effect because there are two stages to this. When one applies treat, then the question of complementarity is different, and the reason for that, and she hasn't said it here, but my understanding is once one looks at the fact that the services of booking for seats is not a core service, a core service provided by that cultural event organizer, then one is looking at the question of complementarity. It has a different starting point. So one is looking at whether, if one is not providing a core service of booking seats, then is it in fact complementary, necessary, indispensable in that way, so that the finding of complementarity stays. Now, it's very brief, I accept, paragraph 21, but what she's saying is the finding of complementarity.
I understand what you're saying about the skeleton argument, but with respect, I don't think that's an answer to my question. First of all, would you accept that this is nowhere in the grounds of appeal?
I'm not sure I do.
All right.
I just have to double check the grounds.
Because what paragraph 6, the grounds, actually does
Yes.
is take issue with the finding you've just conceded, namely overlap in user. Mm-hmm. Whereas you've said that you accept that there is an overlap in user. It doesn't attack complementarity.
I accept that she didn't mention in her grounds that complementarity.
And not only that, it's worse than that, because complementarity is mentioned in paragraph 10, and paragraph 10 was abandoned in the skeleton.
No, this was in the context of paragraph 22.
Well, that's sporting services. Yeah,
Yes.
That may be right.
Yes.
Okay.
So I accept she didn't mention it specifically. In my submission, it's still covered by the point that once one looks at the natural interpretation of these words, of these services, then one has to go on and relook at the treat factors and determine whether they should stand. And she does make the point at 7 that.
Well, that's the sporting
There's a-
point, because in paragraph 7 it's accepted that it might be true of the non-sporting activities, but the distinction is made with respect to organisation of sporting events and activities. What about the other half of my question? Where does the judge base his decision upon the proposition that the hearing officer was wrong to find that the services were complementary?
I will come on to that now. Let me just make sure I haven't missed something. Yes. There is just one point I wanted to make before I come on to the decision, and that's the extent to which this was actually disputed. Now, obviously, I've taken you to the skeleton argument. There are submissions that were made. I note my Lord's comment that we don't need to look at the transcript. I can say that the transcript, what the Respondents' Council did was simply reiterate what was in the skeleton argument. Now, in response, my learned friend did not take a point that the treat factors, in the way that was expressed in the skeleton argument, was wrong, and that there would be a different result once the treat factors are applied, if that construction was applied in the right way. So what the judge was left with was the Respondents' Council's position as to how the treat factors are affected by what I call the proper construction of the services, and there was no response to that. So all he had was Ms. Blythe's submissions and no contrary position. The reason I say that is relevant is because it does inform why the judgment was quite so brief on this issue. Now, the decision, if I could ask my lady and my lords to take the decision, which is at tab 7.
You mean the judgment?
Oh, sorry, yes, the judgment. The tab 7 of the core bundle. Now, the starting point for the purposes of my submission is paragraph 20 on page 77. I'm sure my lady and my lord will be familiar with this judgment by now, but in paragraphs 20, 21, and 22, what the judge was doing here was simply trying to work out the extent to which some of these points were made to the hearing officer below. And during the hearing, he was taken to the transcript references, and in particular the submissions made by my learned friend. And there were a number of issues as to the fact that some of the points hadn't actually been put to the hearing officer. It's not particularly relevant for the purposes of my submissions, but that's what he is doing at 2022. Then it's same at 23, and then and 24. Sorry, and then at 25 he explains that in essence there was what the hearing officer had done had been to transpose or extend one of the points, a point that was made in relation of booking of seats for shows, to paragraphs 22 and 43, because those submissions were not made to her below. The comparison was actually more about gambling than the booking of seats for shows. Now that doesn't matter because the hearing officer is entitled to take into account what she wants in that respect. So it isn't a criticism, but the reason why this was raised, in my understanding of reading the transcript, was that the judge wanted to make sure that he had a full picture of what was actually argued below, so that there wasn't anything new. Now, then 26 is Avnet, and 27 he addresses a submission that was made by my learned friend about the fact that it was an infringement case. And there was an exchange about that in the transcript. And then at 28 is essentially the essence of the analysis. And it's the same at 29, but that's a slightly different point. So at 28, what he's saying here is Ms. Bly's submission that about what the core meaning is of the respective services. And he says that he simply explains the paragraphs I was taking you to a moment ago. And then at 29, he addresses this issue, this concession that was made by my learned friend about the fact that one could read, well, I think you have the point. There was a point that was made, and it's in my skeleton argument.
Well, can we be clear about that?
Yes.
Suppose we took the view that, as you put it, there was a concession made by Mr. Wood before the judge. And suppose we take the view that, in effect, what Mr. Wood is doing on this appeal is withdrawing that concession.
Yes.
As having been wrongly made.
Yes.
Would you say that he's prevented from doing that?
Yes.
Why?
I would. Well, well, for two reasons. One is, once a concession has been made to that extent, an appellant doesn't get a second bite of the cherry by asking the appeal court to find that the subject matter of that concession should otherwise be found in his favor. But the second point is that this was quite an important concession that was made here. What my learned friend was saying, or was trying to say, was that one could read into the decision that what the hearing officer had in mind was that the provider of cultural events provided a service of booking seats for third-party shows. Now, there was an exchange about that this morning. That just isn't right, and that's been conceded. That the event provider is not going to be providing tickets for third-party shows. They might be providing tickets for their own shows, but not third-party shows. Now, this was something that my learned friend had raised for the first time on appeal. It hadn't been raised below. It hadn't been put in a skeleton argument. And it wasn't something that was referred to in the decision. So it wasn't something that was obvious on the face of it, was the right interpretation of the hearing officer's reasoning. But what my learned friend said was, if I'm wrong about that interpretation, and that, as a matter of fact, the hearing officer only had in mind that the event organizer sells their own tickets, then I accept that she probably has fallen into error. And the judge said, well, that's a fair concession, and I accept that. Now, I know that my learned friend has tried to say in his skeleton argument that there was a misunderstanding as to what that concession was.
Yeah, you say there's no misunderstanding. The transcript reveals that the judge was correct. That's
correct, yes. And when one reads the transcript, it is quite clear from the beginning that the words that they are discussing is the booking of seats for shows for the organizer of the event. They're not talking about the opponent's services, and you get that from the transcript. We say it's very clear.
To be sure, but what if Mr. Wood, in the heat of the moment, misunderstood?
Yes, well,
because he's clear, and I think he's always been clear, that in the opponent's specification, booking of seats for shows is a standalone service. That's paragraph 12 of his skeleton in this court, as I pointed out earlier. The question is, what did the hearing officer mean in the third sentence? And it's perfectly understandable that under pressure in the course of submissions, he might have got the two confused.
In my submission, that you don't get that when you read the transcript. It's pretty clear, and the judge was very clear. He asked 2 times, I think, for that clarification.
Okay, so you say he wasn't confused. All
yes.
right.
But if he was,
but let's assume you're right. He wasn't confused. But
yes.
What if it was a wrong concession?
If it was a wrong concession, it doesn't ultimately matter, because what the judge then went to do was determine the question himself anyway. So he said that is a concession. That was a concession. But he then went. He didn't say, and therefore, I agree. There's an error.
That's very fair of you. Thank you.
So at paragraph 30 and 31 is where he deals with it, and then he explains, and this is the point about failure to give reasons. He explains why he doesn't agree that can be read into it, because my submission was quite a stretch, and he was trying to explain why it was just not. One cannot read that into her decision. But then at 32, he says, I would prefer to say that that the officer did not reach a conclusion in paragraph 21 by relying on something that wasn't in the decision at all. And this is where, paragraph 32 is where everything is really packed in terms of what was decided. What he says is, in these circumstances, I agree with Ms. Blythe's analysis based on Avnet. So what he did was he accepted Ms. Bly's analysis that is based on Avnet, which I took you to a moment ago in her skeleton argument, which she repeated in oral submissions. And then he says, in my judgment, it follows, so the analysis based on Avnet is the construction point, the first point. And then he says it follows that none of the appellant's activities described in paragraphs 21, 22, and 3 and 43 could be reasonably said to be similar to an activity covered by the existing mark, in particular the booking of seats for shows. Now, again, that is a submission that was made in terms of how the treat factors are applied once the error has been found. The effect of that is once the treat factors are applied as explained by my learned friend, which is that the services are dissimilar. And so he accepted that and said it is not a decision that could be reasonably said to be similar to any activity. Now, my lord asked me where that test was applied in terms of the standard on appeal. And in my submission, that is where he's applied it. He said that it is not, in essence, not reasonable to find similarity in the context of the proper construction of the services. Now, except it's very brief. And in my submission, the reason it was brief is because this was not something that was really disputed between the parties. There was a point put forward by Ms. Blythe. There wasn't a discussion about the effect of that by my learned friend. And so he says, accept the analysis, and it follows that there's no similarity. That is the important paragraph 32. The question, and it is, I imagine that the problematic paragraph is 33, because when one reads 33, it does give the impression that there is an identity test that's being applied, and that is because of the words material overlap. Now, in my submission, that is the wrong reading of paragraph 33. What the judge, in my submission, what the judge is doing here is he is saying that the mere fact that the users are the same, the members of the public are the same, is not enough of an overlap to give rise to similarity. So in my submission, what he's saying here is because the only thing that is left in terms of a factor in favor of similarity is the overlap in user, he is saying simply because there is that factor is not enough of an overlap to give rise to similarity. And then he explains what the core meaning is of both of the services. Now, in my submission, what he had before him was he had the Avnet principle was explained to him by both parties. The treat factors are in the decision. They were explained to him in the skeleton argument. There was no opposition in respect of the effect of that. He clearly had the treat factors in mind. He clearly understood what the test was for similarity. And in fact, my learned friend reiterated what the treat factors were in his submissions, and I can give you a reference.
Just on that,
yes.
where does he set out what the treat factors are? I mean, he references them in paragraph 6, of course, but he doesn't set out what they are, and where does he analyse how they apply?
He doesn't. And the reason he doesn't, in my submission, do that, there are two reasons why he doesn't do that. One is because he'd already identified at paragraph 12 that the consequence of finding that there was an error in the interpretation of, the construction of the services. So once he had found that the judge had misapplied Avnet, it was common ground that the services are dissimilar. And that's paragraph 12.
And that's the way that you say it was put before him.
Yes.
And he records that in paragraph 12.
Yes.
And it's a bit of a flip switch situation.
Yes.
If I find that, then this falls in and everybody agrees that it does.
Yes, but he still went further and explained that, and that's at 32, that that he accepted the analysis based on Avnet, and he said it follows that there cannot be any similarity. And then he explains that an overlap in members of the public, the fact that members of the public may he said the mere fact that seats may be booked for shows by members of the public cannot create a material overlap. So he's saying it's not enough that there's an overlap in user to find similarity. So he does have it.
Where does he say that? I don't see any reference to.
Oh, paragraph
overlapping
33.
users.
On the submissions before me, the mere fact that seats may be booked for shows by members of the public cannot create a material overlap sufficient to support a finding of similarity. So, yes, it is brief, but the reason it is brief is because there didn't need to be a full discussion of here are the treat factors in nature and purpose. It was accepted between the parties. But what these two paragraphs give you is a snippet of his reasoning and a snippet of what he was actually had in mind. And he clearly had in mind, in my submission, the treat factors that were submitted to him. It was part of the analysis. And he says the overlap in user, the way I read it, the overlap in user is not enough to create a finding of similarity. So in respect of paragraph 21, in my submission, what he was doing was simply applying the right principles. He wasn't applying an identity test and saying that you needed to have an overlap in the actual services to give rise to similarity. He was saying that the overlap in users was not enough. And in my submission, I say that it was perfectly correct, particularly when one looks at how the matter was presented before him, what was not disputed.
What do you say about the last sentence? In relation to the contested mark, the core or substance of the activity relates to the organising of shows and events for which the booking of seats were available as merely incidental, and no booking of seats for third-party shows and events is involved. So he's saying there, isn't he, that there's no overlap in services?
He is saying that, he's saying that the core substance of our services, yes, it's what he's simply saying there, he's just explaining what the core meaning is of the services. He's not saying that there's no overlap as such. And if it wouldn't make sense. It wouldn't make sense.
Sorry, I was reading that together with the previous one, where he says seats may be booked for shows organised by third parties, but that activity does not include the organising of shows. So he's drawing a distinction, but the distinction he's drawing is in terms of whether there's an overlap of services, isn't he?
He is. I wouldn't read it that way. So the first sentence, it's quite clear that he's saying the mere fact that seats may be booked by members of the public is not enough of an overlap. He's specifically referring to the user there, the member of the public. He then goes on to explain what the core meaning is of both of the services. So he says seats may be booked for shows, but that doesn't include organising shows. And organising shows,
so,
you can book seats,
so
but it's
on
not.
your submission, this is not a finding of overlap of services or looking for an overlap of services. Sorry.
Yes.
It's say in your submission, you're saying this is saying that an overlap in users is not sufficient to create similarity.
Yes, that's correct.
Okay.
And in my submission, I say that follows from the way the case was put to him, his findings in 32. He's already accepted the analysis. He's already said there's no similarity. And the references to the two core meanings, in my submission, they're correct. That's what he says the core meaning is of both of those services. So I think that deals with ground D and the first set of services. Now, if one reads the judgment in the way that I have, then paragraphs 35 and 36 follow naturally, because the starting point, he's already found an error. He's already found that there was a failure to construe the services by reference to their core meaning. And there was even less dispute between the parties on the effect of paragraphs 22 and 43. So there was a submission that was made by Ms. Blythe, which is that this first point cuts across all three grounds, and that was accepted by my learned friend. but what the judge goes on to do is he deals with, because he says at paragraph 32, the same analysis applies to paragraphs 22 and 43 of the decision. But what he does then at paragraph 35 and 36 is he addresses the additional points that were made by my learned friend in her skeleton argument, which I took you to, where she says that essentially the error is even more stark in the context of sports services because one does not, a sport event is not a show. Now, there is an oddity in the decision on this, and it is in, you might have to keep a finger on the judgment and then open up the decision at paragraph 22 at page 101 behind tab 9. Yes, so the so what the judge is saying at paragraph 35 is that he explains why a sporting event is not a show. And then he explains at 36 what the core meaning is of a sporting event. And he explains it's a game or activity which involves physical exercise and or skill.
What about the fact that services includes the word show? So, the second item we have in this group is entertainment in the form of live shows and events relating to motoring or motor vehicles. So, on the wording of the specification itself, it includes a show.
Yes, he's talking here about the sports-related matters. So he's speaking about the references to sports events in the services that are covered by 21 and 22. So in 21, it's organizing of sporting activities, that's one of them, and then organizing of motor vehicles, entertainment of live motor sport races.
Entertainment in the form of live shows and events relating to motoring or motor vehicles.
Yes, I mean, it isn't clear to me whether this paragraph relates specifically to that, but it does go wider than that. I accept that it does say live shows there, and if it may well be that he wasn't referring specifically to that, but there are other sports-related events in the services above 21 and services above 22 that he's also referring to. So I don't know why that wasn't taken into account. But what he's saying is that a sporting event is insufficient to make it a show. He explains that a sporting event at 36 is the core substance of a sporting event is a game or activity. And then he says, the officer's decision does not supply any reasoning as to why sporting event or motorsport event should be considered a show. And in paragraph 22, for example, so paragraph 21,
well, first let's take it in stages.
Yes.
She puts out a heading with the relevant services.
Yes.
And she starts by saying the organisation of different types of events. Now, would you accept that that's a compendious way of referring to the events in her heading? Must be, mustn't it?
Yes, yes, of course, yes.
Right. And what she goes on to say would also involve the provision of a booking service for seats at that event. Now, what's wrong with that? Let's take motorsport, motor vehicle races by way of example. Would you dispute that generally speaking you watch a motor race from a seat and that seats can be booked in advance?
I do not dispute that.
Right, so where's the hearing officer gone wrong?
Well, the reason the judge says she's gone wrong is that he did not consider, the way he looked at it, and it's quite clear from 35 and 36, is when one looks at the core meaning of a sporting event, it is not a show. And the reason he says that is because the basis, so one has to look at paragraph 21 and paragraph 22. Paragraph 21, she talks about that Mr. Wood had submitted that these terms could include the provision of theater shows, and that there's therefore some similarities. So she's talking about theater shows. That submission was only made in the context of cultural events. It was never made in the context of sports. So
because it's not relevant when you come on to sports. When you come on to sports, you're comparing booking of seats for shows, unspecified, on the one hand, with a specification on the other hand that, as I pointed out earlier, includes within it entertainment in the form of live shows and events relating to motoring or motor vehicles. And here, of course, makes the point, well, if you're, that would there will be a booking of seats for that event as accepted. And her conclusion is similarity. Now, what's wrong with that?
I think, my Lord, we're cross purposes because I was looking at paragraph 21 and I think my Lord is looking at paragraph 22.
Yes.
So, sorry, my point in relation to 21 was that it had been submitted to her that these terms, she says these terms, include the provision of theater shows. These terms that she's referring to is the cultural activities because there was no submission made.
But this is the usual problem.
Yes.
Of which, you know, the practitioners will be very familiar with, but not everybody in court will be familiar with, is the absence of subdivision. All right?
Yes.
So you have to take each as a whole. So what we're talking about here is the service of organisation of sporting and cultural events and activities. That has to be objection-free in order for the application to proceed. Therefore, if there's an objection to any part of it, it's bad as a whole.
Yes.
So the fact that it might be unobjectionable with reference to sporting doesn't help if it's objectionable with regard to cultural.
Yes, I understand that. Yes. Yes, I understand that. But
and as Mr. Wood pointed out, the way you deal with that is by amending your specification. So if the problem is with cultural, you can strike out the word cultural. But that was never done. So we have to take the specification as it is.
I agree, and I accept that. All I'm trying to explain is where the judge's analysis in this respect. The judge is dealing with 21 and 22 together in paragraph 35, and he's talking about sporting generally. But what he then says is he deals with it generally, but he applies that to both 21 and 22. It may be that it doesn't matter in the context of 21 because they are attached. And one cannot split them out. But in the context of 22, what he's saying is, when you look at the core substance, a sporting event is not a show. And that does apply for all that is not the one that my Lord identified, which says live shows. And what he's saying is that he's explaining why, in addition to what he'd already found in the context of paragraph 32, that the decision doesn't stand because one looks at the core meanings. It's the same point that yes, one can sell tickets, but it isn't a core meaning. Sorry, it isn't the core meaning.
Indeed so. So as you rightly pointed out earlier, the judge said that if the core meaning issue applies equally here, and one understands the reasoning for that when you look at the first sentence of paragraph 22. But he seems to be going on to say that independently of that, there are other objections with regard to the sporting events.
Yes.
And that's where I'm wanting your help as to where the judge says that the hearing officer has gone wrong in a way that stands up to scrutiny.
So,
because if the hearing officer's gone wrong on the core incidental point, and the judge is right about that, then the other points don't matter.
Yes.
Because you've already made that point, and it must be right.
Yes.
So we therefore have to assume, for the purposes of this discussion, that the judge is wrong about that.
That's correct.
And we then ask ourselves, well, he seems to be saying that there's some independent objection to the hearing officer's analysis with regard to the sporting events. So what is the independent objection which you say the judge was correct to uphold?
It seems to me that the core of this is in paragraph 36. He's saying that, and it is difficult because it does relate back to the core meaning point, because he does talk about the core meaning being, in the first sentence, he talks about the core or substance is a game or activity. But then he goes on to say the officer's decision does not supply any reasoning as to why a sporting event should be considered a show. So I think what he's saying is that because it's not, he doesn't, in his view, it's not a show, it cannot be similar to booking of seats for shows. But I'm not sure it stands up on its own. It seems to be related to the core incidental point because of the first sentence of paragraph 36. And I don't think it was being put forward as an additional point.
Well, in the grounds of appeal it was. In the grounds of appeal it's clearly put forward as a separate argument. I appreciated that in the course of the hearing the two may have got intertwined. But on the face of the grounds of appeal it seems to be a separate argument.
The point that was being made was that that when one takes away the cultural events, one looks simply at sporting events. That cannot be, when one looks at the core meaning, it definitely is not a show. It is not something that would be deemed a show, and therefore the booking of seats for shows would not be similar to a sporting event, which is not a show. The reason why paragraph 21, the hearing officer said that there was, part of her reasoning was that the events, that the terms include the provision of theatre shows. So I think the point is that sporting events is not a show, and therefore it's even further removed from the cultural events. And then he's just saying that's not addressed.
You're absolutely right. That is what the judge says. But what I'm still struggling to understand is how you justify that in circumstances where one of the services that was in front of him was, quote, entertainment in the form of live shows and events relating to motor or motor vehicles. It expressly includes the word show.
I cannot justify it in the context of that service.
Right.
But that doesn't mean that his analysis is wrong in respect of the others. Okay. It may be that was not, that was maybe not brought to his attention, or it wasn't in his mind that particular one had the word shows in it. But the discussion below was more about the sporting events, and it may be that the umbrella term lost specificity when looking at that specific term, but it doesn't undermine his reasoning as a whole. The fact that it may have been swept in to that discussion at 35 and 36. I'm conscious of time, and I want to leave my learned friend some time to respond. I didn't have anything further to add in the context of the first three grounds. I wasn't going to add anything in relation to
you've
the
taken
next
the those in your skeleton argument.
Yes.
And Mr. Wood didn't say too much about them orally either.
Yes. So unless there's anything else I can assist my lady and my lord.
Well, what about your respondent's notice?
Yes, I was going to come on to that, and it's fairly brief. I think I'd made an error in my skeleton argument because I identified two scenarios in which this actually comes about. This only really arises if my lady and my lords find that the treat factors were not applied by the judge and ought to have been applied by the judge. So this, obviously, if he was right to have if he was right on the construction of Avnet, and that the services are to be construed in the way that he said, he then should have gone on to apply treat. I've said, as you know, that he has applied treat. He did have that in mind. But if he didn't,
yeah, so
I've
as
applied
I understand
for
it,
you.
the hypothesis here is your primary submission, which is in response to the appeal, is that the judge was right to proceed on the basis that if the hearing officer had gone wrong on the core incidental distinction, then it followed that her analysis of similarity couldn't stand, and that would necessarily lead to the conclusion of dissimilarity. So that's your primary argument.
That's correct.
But here, by way of respondent's notice, you're putting forward a fallback position, which is the judge was right to conclude that the hearing officer had gone wrong with regard to the core incidental point.
Yes.
But he shouldn't have assumed that he was wrong to proceed on the basis that it automatically followed that there should be dissimilarity.
Yes.
And instead he should have gone on to use language from elsewhere in the law to remake the decision. And that would have involved doing the treat analysis himself.
Yes, that's correct.
Yeah.
So if he had gone on, that's exactly right. If he hadn't just accepted what was submitted but went on to do the analysis, he would have found that there was dissimilarity. In relation to cultural activities and, well, the first category in paragraph 21, it is essentially the same points I've already made. The only thing that would change is complementarity. There would still be an overlap in user, obviously, but the complementarity would change. And I have set this out in my skeleton argument, but just to make the point, when one looks at complementarity, one has to look at whether the services are indispensable. The fact that, and the case law does say, the fact that they are used side by side is not enough. The average consumer has to understand that they are being supplied by the same undertaking. And there are examples given about wine and wine glasses, and the fact that the wine is being provided by one provider and the glasses are another. The fact that you use them together is not enough. So in my submission, when one is looking at the core services, the entity that's providing the event, organizing the event, may sell their tickets, but one would not necessarily think that the entity that is selling third-party tickets, there's a Ticketmaster example that was provided in course of submission.
Well, that's a good example,
because
what do you say to the fact that Ticketmaster, as is well known, has been since 2010 a subsidiary of Live Nation Entertainment?
Yes.
Live Nation Entertainment also promotes shows, mainly music shows.
Yes. It is an unfortunate analogy. And I only repeat it because it was discussed. It isn't my preferred one. But it is, yes, maybe Ticketmaster does provide their own events. But the point here is that there is an entity that is providing, their core substance is to sell third-party tickets. That's what they do. And there is another entity that is providing a motorsport activity, and they sell their own tickets as part of that. There has to be something more than simply the fact that one sells their own tickets to find that there is real complementarity. It is indispensable that they are together. There was an example I had read where, and it was another UK IPO decision where you have retail services for for selling clothing, and then you have clothing, and I think it was shapewear and lingerie in particular, and because it's indispensable, arguably, for a clothing to be sold in a retail service. When it's being sold as online or in a shop, then it may be deemed indispensable, and it's connected in that way that the average consumer would think that actually the person who's offering the retail service is also offering the clothing within it. That was an example, moving away from the Ticketmaster example. But the point here is that once you look at the core meaning, complementarity falls away. And where we end up is the overlap in user. And in my submission, that is not enough to find similarity. It's slightly different for paragraph 22 because, oddly, the the factors that were said to be in favor flipped. And so in paragraph 22 of the decision, tab 9 of the core bundle, the overlap, there was no complementarity. And the trade channels were different. What was said to be similar was the overlap in nature, user, method of use, and purpose. And it is difficult to try and marry the two and why there was such a difference. But when one looks at, again, one is looking at, for example, the organization of motor vehicle races. And the core of that is actually to provide the motor vehicle race event. So in terms of the physical nature of the services or the method of use, when one's looking at what the core meaning is, those would be different. The purpose is different to selling tickets, the method of use is different to selling tickets, and the physical nature of the services is different to selling tickets. So in my submission, all of those would flip. The overlap in user stays the same for both, but again, that is, in my submission, not enough to find similarity. So the result of that analysis would have been finding that they're dissimilar. This, in some ways, supports what the judge had done, which is the logical conclusion, and what was not disputed. There's a reason that wasn't disputed. It makes sense. But I make these submissions in the event that that exercise wasn't done and should have been done. The result is the same. The end result is the same. 43 seems to be the one that the gala, yes, the award ceremonies and gala ceremonies. I mean, the reason she gave was the same as 22, so the analysis follows. It is the providing of a ceremony, of a gala. It's different in nature because it isn't sporting, but it is a similar. The reasoning was the same, so I apply the principles in the same way. And then, if I'm wrong about all of that, and there is some level of similarity, then there's an assessment on the likelihood of confusion. I mean, I would hope.
Is that open to you?
No, I'm not sure. Well, it's in the
because paragraph 10 of the grounds was expressly abandoned below.
Yes, and it was in the grounds of appeal for this case, but I'm not sure it is open to me to remake
you mean
that point.
It's not in the respondent's notice?
I think it is in the respondent's.
Is it?
Is it? Or maybe I've misunderstood. I apologize.
No, you're right. It is. I think it's fair to say it is in the respondent's notice. So I misspoke. But you still have the problem that
it was abandoned.
that ground of appeal was abandoned.
And I accept that that is a problem.
Yeah.
Unless I can assist my lady and my lords with anything else, those are my submissions.
Thank you very much indeed. Mr. Wood?
Thank you, my lady. Just to come back very briefly, just on a few criticisms. I think one of the parts which my friend brought up was the concession, and I think that was a point of some concern. My recollection, and I look at when I look at the transcript from the High Court, it's external pagination 70, and I believe it starts at internal page 54. And if perhaps it's been misexpressed, my understanding is it was the point about the.
Sorry, where are we?
Sorry, I should say. Sorry, it is in
Supplementary.
Supplementary
Divided
bundle.
6.
Tab 6, external pagination 70.
Yeah.
And that's the starting at internal pagination 54, going down from there. In fact, sorry, I should start by saying that. So 50. I've got the wrong reference. I do apologise. I had another point in mind, which is actually the point at page 52 internal, where my friend criticises the fact that we didn't engage in the in addressing what Ms. Blythe below said. And I think at line 8 on internal pagination 52, you can see that obviously the way that we pursued it was that effectively the way that it was being ran by Ms. Blythe missed the point, which was the point that I think you've been making to both of us today, which is the real question is whether or not the decision was wrong, not to just pile in on another potential case. So that's that. Let me just find the reference. I'm just going to find. Sorry, I should have had it ready for you. Yes, it's external pagination 74. I do apologise. An internal page 70. That's where the concession or the discussion that led to the concession resides. And as I said, my recollection was that I was addressing the point as to how my client's services were to be understood. That's how I recollect it. And if perhaps that's got lost in translation, then I can only apologise. That's on me. I don't think I have any more points in reply on our appeal.
Sorry, just so that I understand it, if it were considered to have been a concession, are you have you got anything to say about whether it can be withdrawn?
I don't. I think obviously if the way in which it was decided didn't actually rely upon the concession that I was saying, because the as
a
different point.
Chantrier when accepted, the judge, while recording the purported concession, didn't simply end there.
No.
He went on to give his own decision, accepting the point.
32, 33.
Yes, that's right. 32, 33, yeah.
Thank you.
I hope that deals with that unfortunate point.
Sorry, I interrupted. You were going on.
No, then yes. So I think that dealt with all of our appeal, and then on the cross appeal, clearly our primary position is that he got the test wrong, and you've been taken through all of that, and so we say that all of the cross appeal doesn't really.
Respondent's notice.
That's right. Respondent's notice. Sorry, I should say respondent's notice doesn't.
So it doesn't arise.
Doesn't arise.
Well, you're clearly correct that if you are right in saying that the judge was not justified in intervening with the hearing officer's decision, then there's no room for the respondent's notice.
Indeed.
But what if we conclude, and I appreciate this might be unlikely given the way the arguments have gone, but if we were to conclude that the judge was correct to detect an error in the hearing officer's reasoning,
Yes.
which justified looking at it again,
Yes.
but wrong to treat that as automatically leading to the conclusion that there was dissimilarity.
Indeed. And has to do it again.
So that he should have redone the similarity analysis again himself.
Yes.
The submission on that hypothesis is that if the judge had redone the similarity analysis himself,
Yes.
the conclusion he should have come to
Yes.
is that they were dissimilar. What do you say to that?
Well, I think we can only rely upon the same points that are made in the decision from the hearing officer, which is obviously the point which we begin with the point that you've made to me and to my friend about the crossover between the event organizer and the booking. And my friend says that is wrong on complementarity and pushes on one part of the test on complementarity, which is whether or not it's. Let me just to misquote the term. It's important that I get that wrong. Yes. Indispensable. That was the word which my friend relied upon, the word indispensable in relation to complementarity. And at the paragraph 26 of her skeleton, which is, you'll see that she provides the passage. So I should say that's core bundle, tab 5. At the bottom, and it's external pagination 57. And you can see the part from state there that says indispensable or important on that very bottom line, and that's the general test on complementarity. It's not just whether it's indispensable, but also whether or not it might be important, and then it reads on to in such a way that customers may think the responsibility for those goods lies with some undertaking. And the Lordship has already touched on the Live Nation Ticketmaster crossover, and that we say that would of course be one such example. As to the other factors, the other treat factors, clearly we would say that the users are the same.
Well, that's accepted.
Yes.
Or at least that there's an overlap.
Yeah, indeed. And let me go back to the and on that, I mean, on that basis, that would be sufficient to have, we would say, to have similarity, even on just those few factors.
Some degree of similarity.
Some degree of similarity.
Yeah, and you say that's enough.
It is, because then yes, exactly. So, unless your Lordship and your Ladyship have any questions for me, thank you.
Is there anything else you wanted to say about nature, intended purpose?
No, I don't think those are necessarily ones where I've got the strongest arguments on those particular points. I don't say that they're against us, and my friend doesn't say they're. Well, she says there's no on those, but I don't think there's much more we can say on those. The fact that it's some point away doesn't mean would only
right.
deal with
So
the
you're
degree.
not conceding anything, but you're not particularly strongly pushing those factors. You say it doesn't matter.
No, because once you get some degree, that's enough.
Yeah. All right. Thank you.
Thank you very much indeed, and thank you for dealing with this in such a succinct and helpful way. And thank you to both of you and to the people behind you who've no doubt done a great deal of work as well. We're very grateful. As you'll know, in this court, we circulate drafts of our judgments. And that is what we're going to be doing. You're not be surprised that we're not going to give an extempore judgment now. And when those drafts are circulated, be very careful to abide by the embargo. We take that very, very seriously. And as you'll also know, in this court, we hope to deal with consequential matters either by you agreeing them or by your submitting very short written submissions in relation to those matters that you can't agree, and we decide them on paper. We'll deal with this as swiftly as we can, and we're very grateful. Thank you.
Thank you.